I'm going to start with opening the reasons that she published. Okay, so here she starts off by pointing out that this proceeding was commenced by a creditor's petition, which was accepted for filing on 28th February 2025. On April 3rd, a registrar of this court made directions concerning affidavit material and submissions and fixed creditor's petition for hearing on blah, 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 and transferred the proceeding to a judge. On 15th May, another judge of this court heard the application, and as a consequence of that, had heard a recusal application, and as a consequence of that application, recused herself. She cites the orders here. The proceeding was then allocated to another judge of this court who was asked to recuse himself on the basis that there was a conflict in his hearing the matter due to another matter that he had been involved in. The judge caused the matter to be reallocated. Okay. On 11 June 2025, the matter was reallocated to my docket. I caused this matter to be listed for a case management hearing today, 17 June 2025. The parties were requested to provide draft orders and any affidavit material not filed by 2 p.m. on 16 June. In response to that request, the applicants provided available dates for the hearing of the creditor's petition, which were included in their draft order. The respondents did not respond to that request with either a draft order or any further affidavit material. Instead, the respondents sent numerous emails to my chambers, which included various attachments and embedded links. As is my usual practice, I did not have regard to these ex parte communications. I also directed my chambers staff not to open embedded links in those emails or print out any attachments which came with those emails. Today's case management hearing was due to commence at 9:30. Prior to that, my associate and I were engaged in a case management hearing in another matter. At 9:11, the respondents transmitted another email to my associate, which attached an interlocutory application. A further email was sent at 9:28 a.m. attaching an amended version of the interlocutory application. Neither email was seen by my associate until 9:30 a.m. The amended interlocutory application became MFI-1, as it did not appear on the electronic court file by the time that the hearing was in progress. According to counsel who appeared for the applicant, she had only seen the interlocutory application for the first time at or shortly after the commencement of the case management hearing as well. For these reasons, and as the interlocutory application was not yet appearing on the electronic court system, or electronic court file, it was not appropriate to either deal with the application of the case management hearing or to hear submissions from the parties as to whether the interlocutory application should be heard and determined before the creditor's petition, as was sought by the respondents. While some submissions were made by counsel for the applicants, it was apparent that the applicants needed more time to address the matters in the interlocutory application. I also wish to hear from both parties as to why it was necessary to defer the hearing of the creditor's petition until after the matters in the interlocutory application had been addressed. For that reason, I made an order that parties file and serve submissions on that issue limited to 10 pages. Although I did not hear from the parties on the issue of how long they would need to file and serve submissions, it seemed to me that a period of 10 days would be sufficient. I note that the submissions referred to in the order are not as to why the relief sought in the interlocutory application should be granted. Rather, they are submissions as to why the interlocutory application should be heard and determined prior to the creditor's petition. The second order that I made was to set the creditor's petition down for hearing on 28th and 29 July 2025, being dates which suited the applicant's counsel and which were not subject of objection by the respondents. As the creditor's petition was filed on 20th February 2025, it is appropriate and indeed important that it be listed for hearing as expeditiously as possible. Yeah, we have the High Court version of this, I think, if it's the same authority. So she's saying that this thing was listed on 20th February 2025. We have issues about whether or not the petition was validly lodged. Then on 3rd of April, blah, blah, blah. So she's talking about the decision or the orders that Judicial Registrar Ellis made, which are no longer relevant because it's a de novo hearing. Okay, None of this is relevant. She's only doing this to create a narrative. Then she says on 8th May, she vacated the hearing to transfer the proceeding to a judge. None of this mentions that we made the application on the 3rd of April. So for her to pass the thing. Okay, this basically shows that we caused at the last minute for the matter to be
before judge.
Yeah, and obviously she can't say it like that because it would be completely false, but she's created a narrative here. That was the purpose of saying the registrar made decisions, because there's no other relevance of it. On 15th May, a recusal another judge of this court heard a recusal application, and as a consequence of that application, recused herself. Okay, nowhere does it mention that she was appointed at the last minute after this thing. The applicants then confirmed that there was a perceived conflict, that the judge had been working for these people or blah, blah, blah. She says a recusal application was made. Okay. Then the proceeding then allocated to another judge who was asked to recuse himself on the basis that there was a conflict in the hearing, in his hearing the matter due to another matter that he had been involved in. That judge caused the matter to be reallocated. Now, a number of things here. Firstly, she doesn't mention the fact that shortly after the first judge had recused herself, the respondent sent an email to the court identifying names of judges that they had a conflict with. And the registry wrote back, said that if they weren't going to do anything about it, then we requested that the matter go to the Chief Justice. And any judge who is, given this case to consider whether or not they're conflicted. The registry failed to do that. Because they failed to do that, we then wrote to the judge to confirm whether he knew about this. And as soon as he realized, because the names of the parties are different, your name was not in that proceeding. The purpose of us writing to him was to say that if he knew that you were involved in that proceeding, he would have himself ruled himself, accepted that he was conflicted. And he accepted that. She doesn't say that here. I mean, she has an agenda here. It's not even a matter of opinion. This is a science. There are ways in which you interpret these things. What she has done is she's raised every prejudicial matter, and the things that are in our favor, she has basically she hasn't overtly lied about them, but she has expressed them in a way that takes the path that would be to our credit or to our benefit away. Then, in response to that request, the applicants provided available dates. So on 11 June, the matter was reallocated to my docket. I caused this matter to be listed for case management today, and requested the parties to provide draft orders and affidavit material not yet filed by 2 p.m. on 16 June. In response to that request, the applicants provided available dates for the hearing of the creditor's petition, which were included in their draft order. The respondents did not respond to that request with either a draft order or any further affidavit material. Okay, so firstly, she wrote this. 12th of June. Okay, so she wrote this. Now, for some reason, I remembered the time that she had given was 12 p.m. because I had opened the email on my phone while I was doing other things and not paying attention to it. So I thought it was 12 p.m. So this is the email that we sent at 1:32. I write on behalf of the respondents and apologize for the respondents' failure to comply with the directions by midday today. The delay in the provision of the proposed orders has been on account of the respondents having to deal with the preparation of considerable material in relation to multiple proceedings in the Supreme Court and Federal Court, blah, blah, blah. I refer to the email sent by Ms. Xu in the related proceeding. That the court find that the applicants and the solicitors have committed contempt of court, blah, blah, blah. We are currently finalizing the filing of an interlocutory application, seeking that the court find the applicants and their solicitors to have committed contempt of court and other declaratory relief concerning their misconduct, as well as to issue subpoenas and orders that the court first rule on separate questions identified in the application with the aim of disposing the proceeding or significantly narrowing the controversies, and a constitutional notice, as part of which is described in the correspondence sent by Ms. Xu, which will form the orders we seek regarding the management of the proceeding. The respondents are unlikely to finalize this process by 4:30 p.m. Blah, blah, blah. Then 2:05, April will appear. We note Mr. Silver's, the applicant's former counsel, abandonment of his instructions in the proceeding, and put the applicant on notice that we intend to adduce evidence to demonstrate that the conduct is typical of the LSB's acting counsel in proceedings involving the respondents, blah, blah, blah. This is the second email. And the third email is this, which says that further to his email, I'm just saying that this, okay? And this attaches, this attaches two things, the email and this. So firstly, one email in response to her, one email in response to the LSB counsel's thing. Now, why did we respond to the LSB's counsel thing? Because when there is a change of counsel, the new counsel always acts like, I don't know anything about this matter. As you have noticed, and you've pointed many times. We know nothing about this matter, and blah, 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 blah. So we wanted to put them on notice, the court on notice, that this is what happens. Yeah. All the documents shared through this correspondence will be filed in support of the interlocutory application to be filed by the respondents later today. Okay. So this is affidavit material. Okay, so that's one thing. So she didn't mention the fact that we wrote to her before the time and we requested additional time to respond. Yeah. And she didn't respond to that email at all. Then we clarified exactly what orders we will be seeking. Now, let's have a look at one other thing. This is a game of patient analysis, and everything comes out. Okay, so this is our application. Sorry, submissions that were before Bennett. And this is what they say. Contempt application grounds. Okay, now if you look here, at 9/11, the respondents transmitted another email to my associate. So nowhere does she mention anything about the constitutional notice.
Right, yes.
Do you know why she doesn't do that?
No. Tell me, why do you think she doesn't do that?
She doesn't do that because of section 78B. Just let me bring up the...
Is that in regards to giving the Attorney General sufficient time to address the matter?
No, it's about the court's duty. Yeah, 78B of the... Where a cause pending in a federal court, including the High Court or in a court of a state or territory, involves a matter arising under the Constitution or involving its interpretation, it is the duty of the court not to proceed in the cause unless and until the court is satisfied that notice of the cause specifying the nature of the matter has been given to the Attorney General of the Commonwealth and states, and a reasonable time has elapsed since the giving of the notice. This is the court's duty. Okay. For purposes of subsection 1, a court in which a cause referred to in that subsection is pending may adjourn the proceeding in the cause for such time as it thinks necessary, and may make such an order, may direct the party to give notice, may continue to hear evidence and argument concerning matters severable from any matter arising under the Constitution. Okay?
Yep, no, I understand that. I know that.
For the purposes of subsection 1, a notice in respect of a cause shall be taken to have been given to an Attorney General if steps have been taken, blah, 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 blah. Okay. I mean, you can't imagine how fucking dishonest the judge is on your own without me analyzing this for you. So, according to counsel who appeared for the applicant, sorry, before that here, 11, notice of constitutional notice not mentioned at all. Okay, here also, then we attached an amended version, blah, blah, blah. According to counsel who appeared for the applicant, she had only seen the interlocutory application for the first time at or shortly after the commencement of the case management hearing as well. That's a fucking lie. That's not what she said. She said, so that's not what the counsel said, first of all. But what this implies is that everything on the interlocutory application, the other side saw for the first time after the hearing started. Because this never says anything about the fact that it was a new counsel.
Yeah, no, I understand your point.
Or that the issues had been raised previously. So let's have no. Let's have a look at the let's have a look at this. Yeah, this is Bennett's decision. The primary issue was initially agitated by the the primary issue initially agitated by the respondents was my former professional and personal relationships with Mr. Heath, blah, blah, blah. The authorities above make clear, blah, 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 blah. It is well established. It may be, okay, here. In the course of argument, the prospect of an application to call as a witness, person for whom I had previously acted, was raised, the former client. The former client is not a person that the respondents could call as of right. There is therefore some question as to whether they could legitimately subpoena or call evidence from the former client. So far as I understood, the argument is put on two bases. First, there's in contemplation a contempt application to be made in the present proceeding. The former client would be a person from whom evidence would be or could be adduced. The former client could be called to seek to establish that there is a proper basis to not accept the creditor's petition. Okay, so she cited this as the first reason there is an ostensible conflict. Yeah?
Yes, understood.
Okay, so the first reason she listed for there being an ostensible conflict was because she said that we're lodging interlocutory applications in this matter.
Mm-hmm.
This doesn't arise in their creditor's petition. It arises from our interlocutory application. Interlocutory application 1 for the contempt, and 2 for the determination of a separate question, whether or not the jurisdictional issues, basically. Okay? Now,
Yep.
now here's the thing. Those applications don't need to be made in writing. They can be made orally. They were made orally on that day. The LSB said, well, they are not before you, all that bullshit that they always do and they did before the current judge. I told Bennett that that's bullshit. I can make the application orally. If they're taking this view, the only reason I haven't made it orally just yet is because I've asked you to recuse yourself, and I can't ask you to decide these applications at the same time as I'm asking you to recuse yourself.
Sure.
But if they're taking this position, then we say you decide it now, subject to us not waiving any right in terms of your recusal. So then they were like, even if you're considering a conflict, then you should only recuse yourself at the stage when they launch the interlocutory application, and then only for the interlocutory application. By the way, all these arguments that they were raising, I don't even know what they were for, because they weren't really opposing the recusal anyway. So then I told Bennett that if you decide that the lodgement of the application is a critical factor, then you must give us an opportunity to file those fucking applications. She said, yes, I will do that. She decided that it was not a relevant thing because we have a right to file those fucking applications. We can file them anytime. And those applications were made orally. So she had accepted that the oral making of the applications was enough proof that they are made.
Okay, yeah, I get your point.
Now, none of this is relevant to the history as such because the proceeding hasn't started. Everything up until now is nothing because J.R. Ellis did nothing because it's a de novo after that. When it was supposed to start, it didn't start. So there's nothing. And that's what the issue is. Now, they were obviously on notice of the contempt application. They made extensive submissions about it. They were on notice of the other grounds. They made extensive submissions about it. In fact, during the hearing, before the latest judge, Downs, their counsel said that all these issues about the, preliminary matters that we want to be decided separately, they've already been argued before Bennett. And our position is that it's like ART doesn't have a jurisdiction, blah, blah, blah. So it's not the first time that she saw that notice or the LSB saw that application. Do you understand? But
I do.
okay, so first she has lied because what the council had said was that, yes, I have seen this notice this morning, this application this morning. She hadn't said that I only saw it after the hearing began. Okay, this one lied about it, and it's an explicit fucking lie because she has a copy of the recording, even if the transcript is not prepared. If she's and she made this at the end of the day. She had enough time to look at it. She didn't even have to give it the same day. But if she states a fact, she needs to be accurate because this is what she's doing is she's trying to meet the threshold criteria for the balance of convenience. Basically, the law says that if you refuse to exercise your discretion in a way that prevents harm to one party in circumstances that the other party was not being harmed anyway, then you've committed a jurisdictional error, or in some cases error of law, but generally jurisdictional error, and you should go. So what she's saying is they suffered prejudice. We were basically delinquent, and that's why she came to their rescue. Now, she removed the constitutional notice, even though I had made extensive submissions about it during the hearing. So it's not something that she could have missed. I said, also, there's constitutional notice here. You have to give the fucking Attorney General an opportunity to respond. So you can't start this anyway. And it says duty. So she removed it from here altogether. So she doesn't have to explain that. Then I asked for an adjournment. And I reminded her of the same principle that I just told you, that if she exercises her discretion in this way or that way, she said she didn't mention the adjournment at all over here. This is a hit job. The only reason she's not cursing at us is because then it will be a ground for her recusal. Then the other fact here is that the whole thing started with subpoena. Anyway, if you remember, we asked for Ellis's recusal because of her position in respect to subpoena, like her initial reaction to the subpoena. Do you remember? Well, I remember very clearly. And also, this is the version in your exhibited to your affidavit, that it's because of the way she reacted. We were concerned, blah, blah, blah. And that's all caught in the communication as well.
Yep.
So,
Okay. Yep.
everything was about recusal. The subpoena. And the counsel from the other side also said that their subpoena has been rejected. Subpoena should not be issued. Now, why is all of that relevant? Because she says the first time the applications were seen by the applicant were after the hearing began. And then she says, for these reasons, and as the interlocutory application was not yet appearing on the electronic court file, it was not appropriate to either deal with the application at the case management hearing or to hear submissions from parties as to whether the interlocutory application should be heard and determined before the creditor's position, as was sought, blah, blah, blah. While some submissions were made by the counsel for the applicants, it was apparent that the applicants needed more time to address the matters raised in the interlocutory application. That's a fucking lie. They never said they needed time. It's a fucking lie. The counsel never said she needed time. She says she's seen this, she can address it right now. This is what she's saying. And the only context in which she said this cannot, what she was saying is that the judge cannot consider the interlocutory application because it's not filed. So it's a jurisdictional threshold issue that she doesn't even have to, that was her submission. The second submission was that, or set of submissions were that, in case you don't agree with us on that basis, then these are our reasons why you should not accept them. But what they're saying. She never said, I need time. So think about it. What were we seeking? 2 contempt orders, one against LSB, one against Jared, Heath, and Course. Third, we were seeking subpoena. Fourth thing, we were seeking determination of separate questions. What did she say about, by the way, the first 2, no one can fucking argue that they didn't have notice, at least of the first one. And then, actually both, because in the submissions I've said, Course, Heath, and LSB. Okay, so, and she said this is the thing. Firstly, the contempt application is bogus. Secondly, how can I even see contempt orders against Heath? He's not a party to the proceeding. Okay, perfectly addressed the fucking submission. She didn't say that, Your Honor, I'm just seeing this. What can I do about this? Give me some time to address the court.
Yep.
Third thing, subpoena. She said that subpoena application has been rejected. No need to go back and relitigate that. Fourth thing, separate determination. She said that there is no reason for that to be done separately. It can be done as part of the trial. Those were their submissions. This is a fucking lie. Now, the reason why she made orders for the filing of written stuff was because I told her that if she's accepting their completely fucking frivolous argument that the court doesn't have jurisdiction unless this is filed, then firstly, it is filed because of the email service, blah, blah, blah. Secondly, to the extent that she doesn't accept my submission, then she should just fucking adjourn the matter and let us come back, because the thing will be sealed in, a very short time anyway. So that's what I was saying. She said, though, that why don't you address us about why this should be heard beforehand, and I'll give you this much time. Sorry, you should make submissions in writing. Why I should hear this before, or blah blah blah. So it's bullshit what she's saying about the reason for why she made orders. Also, it's a fucking stupid position to take to say that you give me a reason why the interlocutory application should be decided after the matter has concluded. It's like...
Yeah, I follow what you're saying. Yeah.
To not hear it is to dismiss it. To not hear it before it. Okay, so it's a summary dismissal, basically. Without hearing the matter, you just refuse to live. That's what the thing is. Now, especially because we're seeking separate determination. Now, this is the more important part. She says that I wasn't asking them to address me on the substance. I was just asking them to address me why that should be heard first. Because it's a fucking interlocutory application. I mean, you can dismiss it, but you have to hear it first. No one should have to tell you that, the chronological sequence of things is this way, or time only moves in one direction.
Yes.
Completely stupid, because she's saying it's not the substance, but it is the substance. Because think about it. If you're saying that these people are intimidating my witnesses, that has to be decided before the witnesses are called, doesn't it?
Yes. Yep. Absolutely.
That's why it's an interlocutory application. The rules say it's an interlocutory application in that proceeding. You can't even start it separately, because they want it to be settled right there and before the matter. I mean, it's a common sense thing, and the common law has lots of authorities about how this should be sorted. So contempt, obviously, has to be dealt with before. Subpoena, obviously, has to be dealt with before. You don't even need to give the other side notice of it. I mean, yeah. Yeah. The practice is not subpoenas generally. In this court, a subpoena can be issued only with the leave of the court. The issuing party bears the onus of demonstrating that the subpoena has a legitimate forensic purpose, blah, blah, blah. A subpoena, in summary, to address blah, 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 blah. Though a subpoena can be an important and useful means of establishing the facts in litigation, blah, 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 blah. How to apply for a subpoena. A subpoena request, the issuing party may seek leave to issue a subpoena, making an oral request to the relevant judge at case management hearing, pre-trial hearing, or in any other hearing. subpoena request. That's the first way you do it, orally. Secondly, completing request form, blah, 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 providing it to the chambers. Now, she rejected our oral application that day to issue subpoena. That's what happened. Do you understand that?
Yeah, no, I follow that.
Then a subpoena request may be made without notice to the other parties or the addressee. If the subpoena request is likely to be of significant controversy, the issuing party should consider whether it would be appropriate to put the other parties and addressee on notice, blah, blah, blah. They don't even get to raise an objection to this because we don't need to give them notice. That's the whole point. And the law says that they don't get to raise an objection to this. And that's why you don't have to give them notice. The law also says that anybody who is required to address the court or has a right to address the court should be given notice. And this clarifies we don't have to give them notice because they don't get to address the court.
Sorry,
Sorry?
sorry, I'm just going to call. Yeah, you're still there?
Yeah.
Yeah.
So basically, none of that is relevant. She rejected our oral application for a subpoena to be issued. Now,
Yes.
then we go back here. Upon returning to chamber, for these reasons, blah, 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 blah. I note that the submissions referred to in the order are not as to why relief is sought. Okay. The last relief that we were seeking was relief that the other questions should be dealt with separately. Okay. So she wanted us to address the court about the substance of why those questions should be dealt with separately. Again, it's a summary dismissal if she refuses to list it. Do you understand?
Yeah, no, I agree. I totally agree. Totally agree.
Okay. Now, upon returning to chambers, the respondent sent an email requesting further time to file and serve submissions. We specifically did not do that. We said that we can't file submissions by a certain date, but we're not requesting her because, in fact, I think that's the other thing. Like, she's so fucking dense. I mean, either completely dishonest or dense because she's not picking up. I mean, it's not even a nuance. It's just for clarification. Okay, I'm going to get back to another matter, but I'm just going to tell you this. Unfortunately, the respondents find the time afforded by the court for filing the submissions to be inadequate in light of our pre-existing obligations in other court proceedings, including blah, blah, blah. We would realistically need at least until 7 July to file submissions. However, in expressing this, the respondents do not intend to waive our right to seek Her Honor's recusal, blah, 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 nor do we represent that Her Honor may make orders adjusting the timetable. I mean, this is a very fucking serious omission. Do you understand?
Yeah. No, I understand that she's basically got it all asked round.
I said that she should not make orders before deciding recusal application.
Yeah, well, which is pretty standard.
Yeah, and she says that I asked her to amend the orders. Then she says, by their emails, also seek directions about filing an application that I recuse myself. So what I'm saying here is that I'm not saying that I need orders to file the application. This is a complete fucking distortion, because we don't even need to file the application. What I was saying is that we want to give you advance notice so the matter can be managed efficiently. And she's completely fucking distorted this again. All I said was, how would you like us to notify you now? With the objective of her either scheduling a recusal hearing before the upcoming hearing, or on the day, she's notified of it and is not fucking getting a shock when we call her a fraud for the first time. Then the other thing is that the second order that I made was to set a creditor's petition, blah, 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 28th and 29th of July. And then she says it's appropriate because of this. Now, here's the thing, Peter. The reason why I spent that much time in going through that authority is that the authority that she's fucking chosen is an authority where the respondent basically created all sorts of dramas and kept delaying the hearing of the matter.
Yeah, no, I understand that.
And then at the last minute said they wanted to call a number of witnesses because they were fundamentally changing the grounds upon which they were opposing the bankruptcy.
Yes.
And this was after a lot of very heavily contested, very technical points being raised and them losing those points. And then without any explanation, at the last minute now, they fundamentally want to abandon everything that they had fought for.
Yes.
Not just add new grounds, but also abandon everything that they had fought for. Okay? And then issue a whole lot of new subpoenas. And even then, the judge did not say that it cannot be ever done. He actually studied their documents and the evidence and said, not very likely to help them anyway.
Okay.
That's what judges are supposed to do. She's taken that fucking decision.
So you're saying the inference is that the inference against us is that we're raising a number of issues to
stall the matter, but also the principle doesn't apply in our case, because in that case, what he was saying is that there has to be a limit. In fact, what he said is that courts should give as much help as they can, but there has to be a limit. We've never fucking had one help from the court. All the delays, I mean, we've been fucking upfront. We filed everything on time. We raised, they've not even served the creditor's petition on me yet. And the affidavit said they knew that they weren't serving on me, but they didn't give a shit. On the first day, we said we want to subpoena this. Only one fucking subpoena to be issued on a very fucking narrow issue. The arguments cannot be fishing expedition goes out of the fucking room. It's about whether or not there is any immunity for that kind of communication or not. It's a very narrow point. Ellis, practically showed that she wouldn't issue it. Then at the next hearing, they brought up the recusal. Then right after that, we sent the court a list beforehand. So the reason why we did that was to avoid a situation where we'd have to apply for a recusal again. We've done everything right. And not just everything right, we have proactively tried to stop other people from fucking up, including the court. On the day of the hearing, Bennett admitted that she hadn't read our material. That's why she didn't realize that, what's his name? Glenn was going to be a witness. That was the critical issue.
Yes, no, absolutely. Recall
and
that.
I scolded her for that on the day. And she says, well, you can be angry at me all you want, but blah, blah, blah.
Yeah.
It was her fucking fault.
No, great.
I mean, we have been model fucking litigants. Not just very conscientious, but we know more. We've used everything we can to anticipate, even the fucking warning to her. What she's doing here is creating a narrative. Do you know why? I'll show you why she's creating a narrative. So on the 16th, Lulu writes to her and says that we had written to the registry on the 5th of June and said that the hearing needs to be heard urgently, blah, blah, blah. And besides the reasons that we've mentioned, that the matter needs to be heard urgently, the 642 application, we also add these things. Following further consideration, the respondents have decided to include the issues referred to in section A of Mr. Kuksal's letter that we had planned to file the constitutional notice in this proceeding. The respondents intend to lodge a more comprehensive application than previously foreshadowed for an urgent listing of the next hearing in the proceeding before the end of this week. In addition to previously foreshadowed issues, the application will now also seek to rely on the applicant's tendency to engage in the perversion of course of justice to prevent its opponents from having their matters determined by the court according to the law. The respondents emphasize that the maintenance of the unjustifiable orders which the respondents submit were made in jurisdictional error has the effect of inflicting oppression upon us, blah, 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 without comprehensively stipulating all the grounds in support of the assertion made through subparagraph 5.1 of the letter. The respondents note that Justice Ma's orders in that proceeding, in the 642 proceeding, affected the conduct of the bankruptcy proceeding. Notwithstanding that, Her Honor never presided over the bankruptcy proceeding. The orders in the related proceeding were made in response to an application filed in the 642 proceeding. So they filed an application in 642 for orders in 222. Okay? The judge didn't have jurisdiction. None of the parties was served or given any notice, because even we were not given any notice. On the day, they just fucking sprang it upon us. And forget about notice. We were not even given an opportunity to address that particular issue. We weren't given any opportunity to address any issue. She preemptively fucking made those orders. So, and I'm saying here, we have not been heard about the orders being made in this matter. Then also what she failed to consider was that it's on a, what do you call it? On a beyond reasonable doubt basis. And I cite all these authorities. Then I say, Justice Ma's reasons are conspicuously devoid of any reference to the open court principle. She never talked about the importance of open courts and blah, 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 that she has to. And I said they cannot succeed, okay? All of that stuff. Now, we say that because of all of this, it must be listed urgently, and it must be, 1 second. And we say if she's not available, she should let us know, blah, blah, blah. But we say that we say 1.5 days is what we need, and that we want to cross-examine Heath and adduce additional evidence next week. Okay, this is what we say. Now, the fuckers at the LSB, this is the email that they write. We confirm that we are available on the 1st of July for a hearing of the board's interlocutory application. So they are available. And they say they will only require half a day. The respondent's foreshadowed interlocutory application has a lot in common with the application in the other matter. So we say that they should be listed together. Now, when I told you that, you said, no, they will not be listed heard at the same time. It will be one after the other or something like that. And what they're saying is, if both of them are listed together, then it should be on Monday. We're asking 1.5 days, they're asking half a day. And then for the other contempt application, they're also locking in half a day. The board notes that there's a question that we've raised, Judiciary Act, and the need applicable attorneys general, blah, blah, blah. If the court, now this is important, even the fuckers have more shame than the judge. They're saying if the court is considering the listing of applications on 1 July, it may be suitable for parties to file a. So what he's saying is that you should give them an opportunity to be heard. If the matter is being listed on the 1st of July, both matters are being listed together, basically. Now, if the court cannot accommodate a hearing of both applications on 1 July, blah, 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 then 18 July or 21 July, when they're next available, if the court is minded to list both applications for a hearing on the same date, it may be appropriate that the court make timetabling orders in service of any affidavit material, blah, 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 blah. Will not be required if the foreshadow. And then they say, you know, if that happens, then we agree to their stuff. Now, right after the hearing, this is the email that she wrote to me, her associate. Justice Downs does not read emails that are sent to this email address. What? Just this. She doesn't read emails that are sent to this email address. What is the fucking point of this email address then? I don't. Do you know what I'm saying? Because it says Chambers.
I can't quite read it. It then goes on to say what? Sorry, I can't quite read it on the screen.
So she says the parties are reminded of 3 matters. Okay?
Yeah.
First, Justice Downs does not read emails that are sent to this email address. Full stop.
Yep.
If the parties wish to adduce evidence or make submissions, they should not occur by email. Okay? 12th of June.
Yeah, no, I get when they're saying, well, you know, the submissions or whatnot, you file it.
No. They're saying any evidence, affidavit, submissions, don't ever share it through here. This is because during the hearing, I said we have provided everything to you. Then she's checking, fuck you. Why did you provide it this way? And then on the 12th of June, this is what. If you have to provide any unfiled material, you should email it to me here.
Right.
I don't know if she writes emails from that email address or they're per her instructions. So she says that everything that no submissions, nothing should be done through there, right?
Yep.
Okay.
And then she said, yeah.
Yeah. So how are these not fucking submissions? Tell me that.
Mm.
These are not uncontroversial matters that both parties have agreed upon.
Yeah, no, agreed.
These are submissions that were done in contempt of court, arguably, because in direct opposition to the directions that she's issued.
Yeah, absolutely. Yep.
So she doesn't read emails and don't file anything from here. Then anything you have to file, also anything you email is not filed with the court. Any documents sent before to this email address, if you want to rely on, you file and serve. And then also don't fucking dare record anything we've said. Then this is what I respond. I say, please find attached a sealed copy of the constitutional notice, blah, blah, blah. The respondents had relevantly advised Townstay about the lodgement of the document. For clarifications, we didn't imply that emailing documents to judges' chambers constitutes a method of filing. This is what happened during the hearing, okay?
Yeah,
She was
yeah.
basically checking me. And she would have put it in the reasons as well that, they argued frivolously that the emailing was filing and blah, 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 if I hadn't written this email. So I said, because she's already checked me here, that you're not filing documents by emailing. And then I said, the respondents expressed no, so one, we don't say that we said that it was filed just because it was sent to her chambers. Second, we don't express any opinion in respect of what she's saying, other than we acknowledge that this is what her directions are, without waiving any rights in respect of her honor giving them. Then that assertion, the assertion about the lodging via emailing, was made in relation to emails sent to the registry. That is through this email address, which constitutes their lodgement according to rules, blah, 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 blah. The respondents note that we weren't heard in relation to the timetabling, and she abruptly ran away. And then I say that she cannot make orders because I quoted the authority, the first duty of any court is to be satisfied of the jurisdiction. And then I say that we didn't introduce new emails through the evidence through emails via chambers, blah, blah, blah. And she's trying to fucking vilify us by saying we're sending all sorts of inappropriate material through links and this and that. I mean, the registry accepts filings through Dropbox links. And why YouTube is just as legitimate as anything else. I mean, Gorton saw videos in court. So that was a hit job. Now, anyway, this is the crux of it, yeah? So
Yep.
these that are their constitutional notice, very serious matter, and that we say this. Now, we've said 1.5 days. These fuckers say half a day. We've said that we want to call witnesses. By the way, it was also in Bennett's reasons that we want to call witnesses. What she wanted, and also, this is very important. This is the implication of the reasons, yeah? She wanted the matter to be resolved on the 28th and 29th of July, even though there was an ART application pending, which Bennett had said should be determined first, or indicated that she was leaning. This one said no. It will be decided on the 28th and 29th of July. She didn't give us any opportunity to address the court about anything, including what witnesses we were going to call. Bennett asked us what witnesses we were going to call. She didn't allow us to issue a subpoena. She just listed the matter. So if she was listing the matter for the 28th and 29th, why didn't she let us issue the subpoena?
A good point.
That was the final hearing before the listing of the matter, right?
Yep.
And then, now, this is the crux of it, okay? Then she sends an email. And these fuckers said we didn't file the application on the 17th of June, the contempt application. Okay, now this is her email. The respondents have not filed the interlocutory application. Now, how does she fucking know? They have given evidence to her that we haven't filed. She hasn't heard from us. She's accepting evidence and submissions from them. She reads their emails. So we haven't filed. And then she's given us until Monday, 4 p.m. to file it. And this is a self-executing order. This is why she was painting a fucking picture. The attention of the respondents is drawn to, she's drawing my attention to the rule about constitutional notices and they need to be served on this and that. I fucking tried to teach her about it. And blah, 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 blah. By 27th of June, we should serve, blah, blah, blah. And then she's listed the matter, both matters on the 18th of July. Together at the same time, she's divvied up half a day each. And she says that if we don't comply with the lodgement of the application by Monday, 4 p.m., then interlocutory applications dismissed. The final hearing will occur on the 28th and 29th of July. And, no submissions. Now, these are the orders, actual orders. The respondents file and serve interlocutory application being in the form attached by 4 p.m. on 23rd of June. And then here, now she's instructing us to serve the notice if the respondents comply with orders 2 and 3. Okay, now here, if the respondents fail to comply with orders 2 and 3, then this will likely have the consequence that their interlocutory application will not be heard before the creditor's petition. She's given us 1.5 days to lodge an application. With a self-executing order, we've done nothing wrong. I mean, we could be away. We may not even see this. You never make self-executing. There are high court authorities that say you cannot make self-executing orders, willy-nilly. They can be instruments of injustice. They can basically, what they say is that firstly, there has to be a lot of fucking argumentation, and everybody should get an opportunity to be heard about the need for self-executing orders and all that bullshit. She made them on papers without hearing anybody. And this is a summary dismissal. So no subpoena will be issued. Contempt will not be heard.
Yeah, and I understand the effect of it, absolutely.
No, but on what fucking basis? We did everything right. Self-executing orders are only a tool. It's also clarified, nothing can require the court to make self-executing orders. They're not even for punishment. They're only to prevent abuse. If one party is being so fucking abusive that it's bringing injustice to the other, and there's no other way of doing it, then you make self-executing order. But there has to be an open court hearing about whether or not it should be made.
Okay. So what are we going to do?
Yeah. One final point that I wanted to emphasize was that the constitutional notice, now she started taking attention and she started issuing a number of fucking orders to comply with her duty under the Act and the rules.
Yep.
When we said that it was nothing. And this is the other thing. So do you see here? This is 642, listed at 9:30 a.m. on 18th of July.
Yep.
And any submissions. So no fucking affidavits, nothing, no calling of witnesses. She's just listed the matter straight. She wants to get rid of it.
Yep.
And this thing here, 9:30 a.m. on 18th of July. They're listed exactly at the same time. On the same date.
Yeah, right. Okay.
I told you, what they're trying to do is effectively extend an unlawfully made pseudonym order to 2 proceedings. Because there's no lawful way of doing it. And they did it right after I took Joanne Jenkins' name in the Supreme Court proceeding. And they know that they can't fucking threaten me with contempt because it's not gonna fucking work. I mean, not because I don't give a shit about contempt, because there's no basis to argue that there will be contempt. Anyway, so this is, if there was any doubt, that she didn't want to fucking screw us over. You know, it should be removed by now. Like every single thing. She has lied where she can, then she has misrepresented things where lying would get her in explicit danger or trouble. And she's painted a picture that clarifies that she's doing it for, she's setting things up for later. And never heard us before. One other thing, by the way, never even asked us about our availability on the 18th of July. Okay, I'm gonna end this recording now.